In a medical malpractice case in New York, when you are being questioned during your pretrial deposition by the defense lawyer, can you get up out of your chair and leave and not come back? And if that happens, can the defense lawyer compel you to return back to continue questioning or to get you to come back at a different date and time? You want to know the answer? Come join me for a moment as I show you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is, yes, he can. If you get fed up with the attorney who is questioning you during your pretrial question and answer session, during the course of your medical malpractice lawsuit here in New York, now you're frustrated, you're angry, you're upset, you decide you're not going to take anymore. You get up and you leave. And now your attorney goes running after you and says, what's the problem? And you explain to him how upset you are listening to all of these questions as if you are some type of criminal. In all reality, your attorney is going to go after you and tell you that you've got to return back and finish answering the questions posed to you by the defense lawyer. And if you turn around and say, no, I'm not coming back, and now you get up and leave, you know what's going to happen? Well, first thing that's going to happen is your attorney will go back and tell the defense lawyer, hey, listen, I'm sorry, but my client took off. She's not coming back. And now he's going to wonder why. Why? Is there something you're trying to hide? Why aren't you returning to sit for those questions? So now he's going to have questions in the back of his mind that maybe he's pushed your buttons and now triggered some type of response that he can use at the time of trial. But beyond that, now when he gets back to his office, he's going to ask the judge, he's going to write a formal request to the judge to dismiss your case. Why? Because now he will no longer have the opportunity to have asked you all the questions that he needs in order to understand what your claim is about, in order to understand what your damages are, in order to understand why you believe the doctor or the people treating you caused or contributed to your harm and caused you significant harm and injury. And now, without that information, the lawyer is going to argue that he's at a significant disadvantage trying to defend his client, and without that information, he can't go forward and properly defend the case. And you know what? The judge reading this is going to turn to your attorney and say, counselor, why didn't your client come back? What's the problem? He could have taken a few-minute break. Why didn't he return back to finish answering those questions? And now your attorney has to give some reasonable explanation. If your attorney is unable to give a rational explanation about why you did not return, the judge may direct that a new deposition, a new pretrial question and answer session take place at a specific date and a specific time. And if, for whatever reason, you, the injured patient, do not show up, or again show up, and midway you get up and run out of the room and leave, now that's going to be a significant problem for you and your case. Because at that point, the judge may decide, you know what? The defense is right. They don't have all the information that they need in order to properly defend this case. And this has happened not once, but now twice. You've had the opportunity to sit and be questioned, and you chose to actively get up and leave and not return. In that instance, there is the possibility that the judge will dismiss your entire case, all because you did not want to participate and continue to answer questions by the defense attorney. So why do I share that with you? I share that with you because this question comes up from time to time where the injured patient is sitting there being bombarded with questions for hours and hours, sometimes the entire day or even more, by attorneys who represent the doctors and the hospitals because they want to know what happened in your own words. They want to know what occurred. They want to know how your injuries have affected you on a daily basis. And here's something else you may not know. The testimony, the answers that you give in response to these questions, that's considered your testimony. It's happening before it ever gets to trial. And this takes place in your lawyer's office. And by the way, the answers that you give in your attorney's office during this pretrial deposition carry the same exact weight as if you are testifying at trial in front of a judge and in front of a jury. The only real difference here is that there's no judge and there's no jury sitting in your lawyer's conference room. That's the only difference. But there is a court reporter, a court stenographer, who is there to record all of the questions that you're asked, as well as all of the answers that you give. And really, the defense lawyer is locking you into your testimony so that now, ultimately, when your case gets to trial, maybe a year down the road, and you are asked the same or a similar question, if your answer deviates and is different at the time of trial from what you told the attorneys before during this pretrial deposition, guess what? The information you gave during your deposition will then be used against you to show that there are contradictions and inconsistencies between your testimony. You know, I do recognize that you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet brought a lawsuit but still have questions about your matter, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.